Today on Lawyers with Game, join me and my colleagues from Saul Ewing, where we discuss high-profile employment lawsuits and best practices to avoid litigation.
Hi, everyone, and welcome to Lawyers with Game. If you're interested in learning more about legal issues in the video game and esports spaces, you're in the right place. My name is Darius Gambino, and I am first and foremost a lifelong gamer. I've played on just about every system from the original Atari to the Nintendo Wii to now the PlayStation 5. I'm also an intellectual property attorney with over 25 years of experience advising clients on issues related to patents, trademarks, and copyrights. I'm with the firm of Saul Ewing in Philadelphia, Pennsylvania, and you can find me on Twitter as @PhillyIP. If you're up for a game, you can find me as EaglesFan71 on the PlayStation Network. Today with me are my colleagues, Lisa Koblin and Ruth Rauls from our employment group here at Saul Ewing, and we're going to talk about some issues in the video game and esports spaces. So I'll kick it to Ruth first, if you could say a little bit about yourself and your practice.
Thanks, Darius, and glad to be here. I'm definitely going to get some cool points with my kids for being on a gaming podcast, even though I'm going to talk about labor and employment law. I'm a litigator, grew up a litigator. I continue to litigate cases. However, I do quite a bit of advice and counseling work on the labor and employment side. So I deal with all those questions about hiring people, firing people, discrimination, retaliation, pay equity, anything that has to do with an employee or an employer. I've probably answered a question about it at some point. And when those things don't go well and there's litigation, I can also step in and help there. So I am with Saul Ewing. I'm in our Princeton office, and I'm looking forward to chatting with you all today.
Thanks, Ruth. And Lisa.
Hi, hello everyone. I'm Lisa Koblin. I'm also based out of our Philly office, and I work for Saul Ewing, but I live over the bridge in New Jersey, and like Ruth, work with clients of all shapes and sizes pretty much throughout the country on all those fun legal HR issues that no one really wants to deal with or knows what to do with. So like Ruth, a big part of my day is getting calls from HR and managers and business owners saying, I have this really tough employee situation, or I want to hire someone, or I need to fire someone. What do I do? And we talk through those complex issues. And one thing that, I pride myself on doing is working with clients to understand their culture, understand their environment, and make sure that we're creating policies and practices that really fit your company and your culture. And that's a big part of what I do every day. And it's a pleasure to be here.
Thanks, Lisa. If you like these videos, please like and subscribe. If you want to learn more information about our firm, you can visit us at www.saul.com. And finally, please keep in mind that this series is intended to be a high-level and general discussion of legal issues in the video game and esports spaces. It is not intended as actual legal advice. If you need legal advice, please reach out to one of the three of us, and we'll be happy to help you. So today we are going to talk about employment issues in the video game space, and there's a lot to talk about. There's been a lot of cases going on recently, a lot of big judgments, a lot of problems when it comes to employment and pay equity and gender discrimination in the gaming and esports spaces. So I want to ask Ruth first to give us a brief overview of some of the things we're going to touch on today.
Sure. So I'm just going to lay a little bit of a roadmap for everybody. As Darius alluded to, there have been a lot of news coverage about some cases, some high-profile cases, some big headlines. So we're going to use those to kind of give examples of what we're seeing, talk through some of those issues, and then talk a little bit about what type of anti-discrimination and harassment laws are involved with cases like that, and discuss some best practices to keep your name out of the headlines as you're working through employment law issues.
So we're going to be talking about two of the biggest esports companies in the world in Activision, Blizzard, and Riot Games. Two big cases, McCracken versus Riot Games and EEOC versus Activision Blizzard. Riot having probably the biggest esports franchise in the world in League of Legends, and Activision Blizzard not too far behind with games like Overwatch. So I wanted to ask Ruth first to talk about the McCracken versus Riot Games complaint and resolution.
Anybody that follows gaming and has followed any of the kind of media outlets has probably seen reports and investigative stories regarding the culture at Riot Games. The most, I think, widely publicized story was in an online gaming magazine, Kotaku, which was an investigative report, and it really went into detail about the alleged culture of sexism there, claiming that women did not receive equal opportunities for promotional or leadership roles, that women were treated differently because they did not fit in to the, as they call it, bro culture over there, and really just describing the entire culture at that company as fraternity-like, and was very uncomfortable for the women that were there. Not surprisingly, litigation ensued. And I'm going to just take a step back for a second to kind of emphasize a lot of the things we're talking about today. When employees feel like they don't have a channel internally to make a complaint, or that they're not being heard, or that a company is not taking action about certain things that are being alleged, they go somewhere else. And that somewhere else is often the media or a blog post. We saw it with Uber. There was a big blog post that resulted in litigation there. So I just kind of want to emphasize that a lot of what we're talking about is helpful to why policies, procedures, and things like that are going to be important. So litigation ensued. First, we had a class action that was filed against Riot Games with several women that accused the company of gender discrimination and harassment. And, just a word on class actions. A class action is a case that is filed on behalf of every similarly situated employee that fits that class. So all of the women that were working at this company were part of the class. That translates into a lot of plaintiffs, a lot of money, and a lot of claims to deal with. So class action lawsuits are a big deal. And settlement was initially reached in that class action for about $10 million in 2019. But before that was inked, the California Department of Fair Employment and Housing, which is the state agency that's kind of the equivalent of like the federal EEOC that we hear a lot about, and their task with anti-discrimination and enforcing those laws. They came in and said, I don't think so. Hold on a minute. We've got a couple things we want to talk about as well. So we don't just have individuals suing Riot Games now. We have a state agency that's tasked with enforcing anti-discrimination laws in the mix. And, you can read a lot about the specific allegations in the reports. I'm not going to get into them. I've took a very broad brush approach, but they were significant and they were serious. But I am going to cut to the chase in terms of what ultimately happened. So 2 years later, you can add a 0 to that initial settlement amount. Riot reached a global settlement with the California agency and with several of the private plaintiffs to the tune of $100 million. And it's not just money. The settlement included, for money-wise, $80 million to the class of individuals who are all of the current and former full-time employees in California who identify as women and worked for the company for a period of time. And it also included $20 million for attorney's fees and litigation expenses. And not just the money, it also included some other actions that Riot has to take, which are significant for any company. Riot has to have internal reporting and pay equity processes monitored by a third party that's approved by the California state agency for a period of 3 years. That means a third party, an independent, somebody not affiliated with the company is going to get to be inside the company, look at how they pay people, look at how their policies work, and monitor to make sure they're doing what they're supposed to be doing. So big dollars, lots of money, but also a long time implication in terms of who's coming in and who's looking at things. So, that is a case that really illustrates the type of claims that we can see and the type of resolutions and settlements we can see when we're talking about employment law. And I'll let Lisa talk a little bit about the Activision case as well.
Yeah, I just wanted to mention before we kick it to that. It's so significant, the money amount and all the oversight and everything like that. And I do know that Riot took some actions, maybe as a result of this, maybe independently in the esports space to really get the participation of women in its latest esports franchise, Valorant, to be significant, and they've gotten it to about 30% women now, which is a lot higher than League of Legends, and they're continuing to promote all women Valorant tournaments and things like that. So I think they've taken a lot of this very seriously, and they're moving in the right direction. But Lisa, let's hear a little bit about EEOC versus Activision Blizzard.
Yeah, sure. So another, headline case that I'm sure a lot of us have heard about or seen in the media is a case, like Ruth was saying, where the government, the EEOC, brought a lawsuit against Activision Blizzard and some of its subsidiaries related to claims of gender discrimination, harassment, retaliation, things of that nature. And the way that comes about, just kind of taking a step back, is, an individual goes forward with a claim, like Ruth said. Oftentimes, if you don't have a great internal practice or policy for complaint reporting, or perhaps the complaint is not resolved to the person's liking, they're not satisfied, they're likely going to reach out to the government. All they have to do is go on the website, eeoc.gov, right, fill out a complaint form, and then they're in contact with the government. And when the government starts to investigate, as they did here, they can decide, we actually want to take on this case. We think there's a bigger issue here that we need to investigate, that we need to think about, and we're actually going to take this on. So this is what happened in this case. The EEOC actually first received an anonymous letter regarding sexual harassment, and they did an investigation. This led to not only the EEOC getting involved, but the California State Division, the Department of Fair Employment and Housing, got involved too, and they launched their own investigation. Interestingly, we saw actually a little bit of a battle there between the government and the state agencies, trying to figure out who was in charge of which investigation, who was going to take over. But needless to say, we have two government agencies who are really digging around, really trying to kind of figure out what's going on. We know that's going to be very time intensive. We know it's going to be probably disruptive to operations in a number of ways. And this has been going on for a number of years. So the EEOC investigates, and they reach a resolution with Activision, which is called a consent decree. You might hear about that as well. That's essentially more of an informal resolution with a company, in that it didn't go to court, it didn't go to a judge, but the parties reached a resolution similar to the Riot case, where they reached an agreement which said that according to the decree, that Activision was going to pay $18 million as a result of wanting to settle, reach kind of a global settlement, as Ruth said, in the Riot Games case. And what's interesting about that is, first of all, again, we don't see headlines like this. So, it is significant. It is a significant amount of money, which also breaks down not only to the monetary compensation, but to non-monetary elements like monitoring policies, how they're going to handle internal complaints. Now we have the EEOC involved in all of those processes, but we still have a state case pending. So it's actually really interesting, because since we have two different government agencies handling two different components of this larger investigation, the state did not want the EEOC to settle. They did reach a settlement. It was actually just approved by a judge in June, and we still have a state case pending. And so it'll be interesting to see what happens with that state case, and if the state is going to go for the same kind of dollar signs that we saw in the Riot Games case. So, this is what happens when, you might start with an individual bringing something forward, but if we have patterns of similar complaints or concerns, it can snowball and it can reach these elements. And it makes us stop and think about, okay, what can we do to prevent things from getting to that level, right? So I know that those are the thoughts that crossed my mind when I read about that case.
Yeah, and that's what I was going to ask you. I mean, are there kind of some general best practices that companies can undertake in order to avoid these types of litigations?
Yeah, absolutely. So first and foremost, as I alluded to earlier, we don't want to ignore this stuff, right? We don't want to sweep it under the rug. We don't want to act like it's not happening. We don't want to say, oh, Sally down the hall is just a complainer. We don't need to worry about her. No one thinks like she does, and just don't worry about it, right? We also don't want to have a situation where we do maybe, investigation. We're not really thorough about it. We just kind of talk to a couple people. We don't document, and we just figure, oh, the two people involved shook hands. They're fine. We can go on our way. We really want to make sure that we are setting up, having a team, an internal process to appropriately deal with any issues that do come to light. We can't be mind readers. We can't police people. We can't know every single movement of our employees. Absolutely. And the law doesn't require that. But what it does require is when something comes to your knowledge as a manager, as a business owner, as human resources, you have to take an action to figure out what's going on, when did it happen, who was involved, and how can we take steps to prevent it from happening in the future, right? If you have bad apples, we can't let those bad apples keep working for you, keep making lots of money and moving up. If they really did something egregious, you need to show them the door, because what happens is not only are they unfortunately likely to do it again, but those issues are going to be the ones that blow up and snowball and lead to these litigations, which are very costly. Another thing we want to keep in mind is using common sense. Ruth and I do a lot of trainings for clients around the country, anti-discrimination, harassment prevention. And I can't tell you how many adult people I've stood in front of and said, please don't touch each other, right? Use common sense. Like if you're about to send a text that you don't want your boss to see, you don't want your mom to see, or your kids, and you're sending it to your coworkers, like you probably shouldn't send that text, right? If you're about to tag someone in something on Instagram, or even comments in gaming, right? Anything that relates to anybody you work with, and that could impact them when they come to work, we need to be careful about. And it doesn't matter if you've known someone, they're your childhood buddy, they're your cousin's friend. If you work with them and you could do something to impact their work, we have to take that really seriously. And so the third thing I want to highlight is it's not enough to have these nice policies and these nice statements that maybe we put online, we put in a handbook. They're very important, but we need to back it up with our actions. And so once you figure out, okay, what are our policies and practices going to be, we need to think about who's going to help enforce them. Have we trained our managers to issue spot, to understand when someone comes forward and says something? Your staff are not going to come to you and say, I would like to report that under Title VII of the Civil Rights Act, I believe I have been, they're not going to say that. Nobody talks like that, right? They're going to say, Joe next door keeps looking at me weird and I really don't like it and I don't want to sit in meetings with him. And that could be a big deal. We don't know what Joe is doing. We have to figure it out. And, do you have HR that is knowledgeable, is trained, understands the importance of conducting a thorough investigation, knows when to contact legal, when to contact me and Ruth and Darius to figure out, okay, I think this is something we need help with. These are all elements that these cases, remind us we have to think through in order to avoid these litigations, which are very costly and time consuming and can damage the reputation of a company.
Yeah, absolutely. I mean, the thing that strikes me the most is having a reporting mechanism, just having a way for these types of complaints to be reported, investigated properly. You mentioned Title VII, and I'm going to give Ruth an opportunity here to talk about some of the different laws that impact employment, because there are a lot of different ones, both federal and state, that we need to consider. So Ruth, maybe a little background on that.
So before I start talking about the laws, the employment laws that we're talking about, I do want to talk about two words that we've been saying a lot, discrimination and harassment. And those words mean something in the legal context. It's, not that someone's harassing me to take them out to dinner or my kids wanting me to go drive them somewhere. It means something in the context of law. So I want to just run through what we consider those definitions to mean when we're talking about this. So discrimination is subjecting an employee to different terms and conditions of employment because of that employee's protected status. So what does that mean? That means terms and conditions, hiring, firing, promotions, discipline, things like that. And protected status are these things that we're going to talk about under Title VII. It's on the basis of race, color, sex, national origin, even broader classifications under state law. So that's what we mean when we say discrimination. And when we're using the word harassment, it's really a type of unlawful discrimination. It's a course of abusive, negative conduct that occurs over a period of time. And that can be a whole host of things. That can be physical, it can be verbal, it can be written. It just can be behavior that's unwanted, that impacts an employee's ability to work, and it's based on their protected category. So those words mean something in the context of these laws. So I'm going to start with the federal laws. I always say that kind of sets the floor of what is prohibited and what is protected. And we've mentioned Title VII a couple times. It's Title VII of the Civil Rights Act. We've probably heard civil rights claims or things like that. That's what we're talking about, and it prohibits discrimination against employees on the basis of race, color, sex, including pregnancy and sexual orientation and gender identity, as well as national origin. And so when we're talking about harassment and discrimination under Title VII, those are the type of claims that we're looking at. And that is what's protected. There's also other pieces of that, the Equal Pay Act, and that requires that men and women get paid the same wages for the same work. There's also the Pregnancy Discrimination Act that was an amendment to Title VII. It expanded the coverage of sex discrimination under Title VII to include discrimination on the basis of pregnancy. We have statutes like the FLSA that dictate how and when and how much we have to pay people, and things of that nature. But that's really the floor. And then the next thing we look at are states. State laws and state legislatures have said, hey, we're going to add some additional protections in. We're either going to mirror what's already in the federal law, or we're going to add additional protections to our employees and additional obligations to our employers. So what state you are in is really going to be important as well. The employment laws in California and New York are not the same as employment laws in other states. So, and when you have employees in states that are highly regulated, it's really important to make sure you don't run afoul of those for something as simple as paying people every 2 weeks instead of every 1 week, because that violates their wage laws. So understanding where you are is also going to be important in terms of understanding your obligations.
Yeah, and we saw that before with when we were talking about McCracken versus Riot Games. I mean, the settlement that the private parties reached was 1/10 of the settlement that the state ultimately demanded, and that was the state of California. So it really, we can't neglect the state aspect of all of this. So I wanted to ask you, as I asked Lisa with, some of the things she was talking about, what are some best practices to avoid harassment and discrimination? We all know about trainings and things like that, but what are some, best legal practices so that these types of claims are minimized and hopefully eliminated?
Sure, that's a great question, Darius. I think when we're looking at what we can do and what we need to do as employers, it's really important to know what your state law requirements are and what jurisdictions you're sitting in. In some states like New York and California, you have mandatory training obligations. So in addition to, you should probably be doing them because it's the right thing to do and it helps protect you, you're also sometimes legally required to do them. And it's important to understand what the parameters are for those trainings and things like that. So when we're talking about, what employers can do to reduce risk, to reduce financial exposure, culture starts at the top. You have to model appropriate behavior, take things seriously, and start at the top down, because policies, as Lisa was saying, trainings, things like that, they're not worth the paper they're written on if we're not actually following them and implementing them and putting our money where our mouth is. If we see something, we do something about it, and we make sure that we're adhering to those policies, we're following them, that we are following through, and we're taking corrective action if we have to. And if that means certain people have to be terminated, then those are hard decisions, but they're decisions that have to be made to stop employees from feeling like they don't have a place to go with their complaints. And they may go to an alternative source. That may be the media, that may be the government, that may be the state government. And then you'll find yourself in a situation like some of the cases we've been talking about, where you have state investigators inside your doors looking through files and seeing what's going on. So it's really important to walk through how you're going to deal with those issues and have proper procedures and safeguards in place to deal with them. Another thing, we were talking about reporting and things like that. It's also really helpful for employers to have more than one way to report an issue, because we have to recognize not all of our people feel comfortable raising a complaint in the same way. I think Lisa said, no one's going to walk up to you and say, I have a complaint under Title VII. Some people aren't going to walk up to you and tell you they have a complaint at all. because they're not comfortable for whatever reason. So things to consider with respect to complaints are you can submit a written complaint. You can come up and talk to somebody. Anonymous reporting hotlines are also something a lot of companies use, because it's really, if we don't know about it, we can't do something about it. So providing avenues for people to be able to bring things to the attention of management really is important. And you learn a lot that way about your employee base. You can also do climate surveys to kind of find out where things may be percolating around a bit before they've actually bubbled up, and ensuring that there's a good relationship between your HR team, if you have one, or your leadership team and your managers and supervisors. Because when information doesn't easily flow between them, sometimes things get missed. So having open communication lines are also just good practical tips for dealing with how to reduce risk and understand what's going on a regular basis with your employee workforce.
Lisa, I wanted to ask you, one of the issues that's come up in some of these cases in the video game industry is equal pay. And obviously, I understand that that means men and women should be paid the same for the same jobs. But can you explain a little bit legally about what the requirements of equal pay are, and some things that companies should be thinking about when it comes to that issue?
Yeah, absolutely. So first of all, I think we just need to acknowledge, and it's important for companies and management to acknowledge there is still a significant gender pay gap. It's been analyzed every which way it can be. It still exists today. I think it's 84 cents to a dollar for white women. For people of color, it's much less. It still exists. So, obviously we've heard about Me Too over and over again, and people are probably sick of that term. But what that movement did is it reignited in especially state and local government, to some extent the federal government, to issue new laws, new legislation to say, here are different ways we're going to combat this gender pay gap, to really try to even the playing field, right? To make sure that we do have men and women who are doing the same job getting paid for the same work. So an example would be states like Colorado, New York, and others, which have said when you post for a position, whether it's a promotion, whether it's a new hire, you have to put your salary range on there. It can't be, will be decided based on experience, right? And more states are doing that. Another example is, I believe there's 14 states in Washington, D.C. throughout the country, which prohibit you from asking an applicant, what is your current salary? And that's because women have been historically paid less. And so they're going to continue to be paid less if you're basing their new salary off of their existing salary, which maybe is lower than it should be, right? So there are states which have said you can inquire. You can ask someone, what would you like to earn, and ask them to provide a range they're looking for. But we don't want to cross that threshold and violate the law, and ask them what they're earning. But again, this is state specific. So it's another reason why, like Ruth said, understand, your landscape, where you are, where your employees are. On that note, I don't think we've touched on this, but if you're a company that's based in California and you're hiring someone in Florida, in Colorado, in Chicago, the state where the employee is working are the laws we're going to be concerned about for that employee. So California is fun in and of itself, right? That's, it's almost like another country out there. So you're going to cover a lot. But let's say you're a Florida-based company and you're hiring in New York, or you're hiring somewhere different. It really matters where you're recruiting from, whether they're remote, whether they never step foot in your corporate office. It does not matter. We need to think about, where are these people coming from? So we want to acknowledge that there's still a pay gap. We want to understand what our state and local laws are. And then we want to think about, when you're creating that salary range, or you're promoting someone and you're giving a raise as a result of promotion, where is that decision coming from? Who's making that decision? Is that decision consistent across the board, right? And what happens is, you might have a star employee and they're amazing talent, and you want to do literally anything you can to keep them. And so you will put that money on the table to keep them. And someone else in the same position is not a star player and they're not in the same range. And to some extent, that is okay. It's not that you can't reward good work. But when we start to have these groups grow further and further apart, we don't have documentation to back up why it's different. And then we're continuing these trends, and the star person happens to be a white male. It could get you into hot water to say, well, okay, how did we get here? So we really want to take a step back and think about these practices. when you're interviewing? Are multiple people interviewing candidates? Are you working with your human resources to make sure that you have consistent questions and criteria? I think it's very common, especially in startups and maybe smaller businesses. You start by hiring people that's totally understandable. It might be a friend of a friend, it might be someone you used to work with, and that's all good and well. But if ultimately you're hiring people who think the same way as you and look the same way as you from the same place all the time, and you have that one applicant who's very different and stands out and you don't hire them, we could start to get into a gray area where it's like, well, why does everyone look like you or act like you? Or why is it that, the one female person of color just so happens to make less than, her male counterparts, right? And nobody starts a company, at least I like to think, nobody starts a company thinking, I am going to pay women less. I am going to discriminate and pay. That is my goal, right? People don't think like that. Most people are good people. They want to reward hard work. And that is totally understandable. But we need to make sure that you're doing that in a way that is compliant with the law and that isn't going to get you into hot water down the line. And at the end of the day, people talk, right? I know a lot of people who've been in situations, I've been in situations where when you find out someone is making more money than you and you do the same job, you start to question, you start to think, well, why is that? And if you have no transparency, there's no process that people come to learn about as to why that might be. That's when the rumor mill starts. That's when the morale issues creep in and you have turnover, and we want to retain that talent. And we know how important that is.
Yeah. I mean, undermining morale more than anything else that we're talking about today. And, it's a non-legal issue, but I mean, when you have that pay gap, it really undermines the morale of your employees, and starts to make them think about, going elsewhere. So Ruth, I want to end on, I understand one of the things that companies can do to get ahead of these issues is to do an analysis of pay within the company. Can you talk about that type of a study, and what that can do for a company in looking at equal pay issues?
Sure, and it's something that we're seeing a lot more of with all the laws that Lisa was talking about, and states being a lot more proactive in this space. It's something we call, a pay equity audit, a pay audit. And even without the laws, it might be a good idea just to figure out how we're paying people across our company. Because I think one of the things Lisa was pointing to is, maybe someone starts at a slightly higher rate and somebody starts at a lower rate. And as promotions keep going, it creeps in, and it creeps in slowly, but can get bigger. And pay audits are a great way to kind of figure out where the creep is, and see, where there is a difference. Now, if you're going to undertake this, the planning is almost as important as the actual analysis. What is the purpose and the goal? What do we want to accomplish? Because you're going to get a bunch of data in. What are we going to do with it, and how are we going to look at it? How big are we going to go? Are we going to look at just one state? Are we going to look at just one business unit? How are we going to define our business units? Are we going to look at managers across the board within different divisions, within different geographic locations? And what time periods are we going to look at? And what physical locations are going to be covered. And once you kind of set that up, you have to remember, when you're looking at pay, it's not just base salary, right? We all get a base salary, but compensation comes in a lot of different forms. It could be equity. It could be phantom stock units. When we're talking about startups, equity, incentive comp, that's a big deal. And that money adds up very quickly. So when we're looking at a pay and a pay audit, you want to make sure you're gathering all the salary information, but you want to look at the total comp too. What are the equity incentives? Are they the same? Why did one person get this and one person get that? And what was the decision making there? And looking at those points and understanding kind of what you're getting in. And once you've put all of that and organized it in the functions that you want, you have to start looking at race, gender, age, ethnicity, education, experience, performance, and saying, wait, is this matching up, or am I seeing differences here? Am I seeing trends that are not what I'd like to see? And the reason I say you have to plan before you get the data is because you don't want to get the data and then kind of put it in the places that you want so it matches up, right? Because the point of doing these is to walk into them eyes wide open with the understanding, I think, of what, Lisa pointed out. Nobody, we all hope, starts these things, setting pay, going, I want to pay this person less because of this. It just sometimes inherently creeps into the system based on the historical nature of pay disparity. So be open to recognizing it, seeing it, and take actions to fix it if you see it. And doing that is helpful, not just because it's good for business and it's the right thing to do. It also provides you with some protections under law and it's sometimes maybe a claim pops up or something. There are safe harbor provisions showing that you've tried to, you've addressed these things, you've looked at them, you've tackled them, straight on. And that makes a difference when you start dealing with state agencies or even claims for this type of thing, because you can say, hey, this is why these individuals are paid differently. These are the things that we consider. These are the experience levels. This is the seniority. This is why there's a difference here. And a pay audit really allows you to do that. And it points out red flags that you just might have blinders on for. You're worried about running a business, you're worried about getting work done, and things creep in and build up and you just aren't focused on it. And this is a really good way to get you to see that and be able to work on communication issues and fixing things as you go forward. Should you see an issue, hopefully you say, this is great. We've set all of our pay perfectly. We have great ranges and we don't have anything to worry about. But we're going to see states take more and more action on this because it seems to be a very hot button issue and a lot of oversights coming into play here.
Yeah, you certainly don't want the first time you look at these issues to be when the agency, whether it's federal or state, is investigating you. Certainly. That's all the time we have for today. This has been a really interesting and informative discussion for me. I hope for everyone else out there as well. If you have any questions about any of the legal issues that we've talked about today, you can drop them into the comments, and Ruth or Lisa or I will try to answer them without providing any real legal advice, of course. Thanks for joining us. Until next time, I'm Darius. This is Ruth and Lisa, and we are Lawyers with Game. We'll see you next time.